Linan, Pimentel, Recto, Revilla, Soto, Trillanes, Villar, Senate President Enrile.
With 18 senator judges present, the presiding officer declares the presence of a quorum. Majority Floor Leader.
Mr. President, may I ask the Sergeant at Arms to make the proclamation?
The Sergeant at Arms is directed to make the proclamation.
All persons are commanded to keep silent under pain of penalty while the Senate is sitting in trial on the articles of impeachment against Chief Justice Renato Corona.
Majority Floor Leader.
Mr. President, I move that we dispense with the reading of the February 20, 2012 Journal of the Senate sitting as an impeachment court and consider the same as approved.
Is there any objection? There being none, the February 20, 2012 Journal of the Senate sitting as an impeachment court is hereby approved. Majority Floor, the
Call the case,
Secretary will please call the case for the Senate sitting as an impeachment court.
Case number 002-2011 in the matter of impeachment trial of Honorable Chief Justice Renato Corona.
Appearances, Majority Floor Leader.
Yes, the prosecution, Mr. President.
Good afternoon, Mr. President, and the honorable members of the Senate sitting in impeachment. Same appearances with the prosecution,
Noted.
Your Honor.
The defense.
Your Honor, please. The same appearance for the defense, Your Honor.
Noted.
Thank you. Mr. President.
Majority Floor Leader.
Yes, Mr. President, may we recognize Senator Miriam Defensor Santiago?
The
For the
lady
business for today.
senator from Iloilo.
Both counsel, please take your seats.
Thank you, ma'am.
Mr. President, first, I humbly beg the indulgence of our colleagues. Particularly, I apologize very profusely that I always take the floor at the beginning of the impeachment trial. The reason is medical. After 2 months, it is only now that my blood pressure has become normal. But I'm now suffering from chronic fatigue. If you remember, a couple of years ago, I took prolonged sick leave because of chronic fatigue. This period's chronic fatigue might be caused by the fact that I'm suffering from what is called in layman's terms, lazy bone marrow. That is to say, my bone marrow apparently does not manufacture enough red blood cells, and I have to be injected every week to get my blood cells to normal. That is the reason why I cannot stay long. That is why sometimes when I'm speaking, I sound like I'm out of breath. Also, not only am I hyperventilating, I have palpitations when I am in trial court. Now to go to the business of the day. Some observers of our proceedings might wonder why we have spent time determining whether the specimen signature card submitted by the prosecution with the qualification that they do not vouch for its authenticity. Some might wonder why we are spending time on whether these specimen cards are true or false. The answer lies in this basic rule of evidence that is expressed in Latin as follows: falsus in unum, falsus in omnibus. This is a very serious and basic principle in evidence. Once the court is convinced that one panel has been foisting a fake document on the court will be then justified in indulging the disputable presumption that if one panel has been lying on one particular, then he has been lying on all particulars and will have to disbelieve everything that that panel offers in evidence. That is the scope and meaning of falsus in unum, falsus in omnibus. Lying in one particular, lying in all particulars. That's why, as a senator judge, I would like to counsel prosecution, be extremely, extremely careful, gentlemen of the prosecution, because you might be treading on very thin ice. Falsus in unum, falsus in omnibus. There was a theory expressed in this court that actually the attachments to the request for subpoena prosecution are not fake or are not forgeries because They are simply, as the bank official testified, they are simply inconsistencies or discrepancies, which the bank official said, according to their count number, over 40 inconsistencies or discrepancies. Thus, we have to turn to our penal code to determine whether the specimen signature cards, both from the bank and from those submitted by the prosecution, constitute falsification. Under the Penal Code Article 171, as related to Article 172, falsification is, by among other methods, committed by, quote, making any alteration or intercalation. Intercalation means insertion in a genuine document which changes its meaning. And by the way, there is a difference between the term forgery and the term falsification. Under the Penal Code, the term forgery is usually applied to banknotes. For example, if you print Philippine pesos or US dollars, then you're guilty of forgery if you are passing off these counterfeit notes as genuine. But if you are falsifying a commercial paper, like a specimen credit card of a bank, that is the crime of falsification. And it is a crime to knowingly introduce in evidence in any judicial proceeding such a falsification. I have a whole list of cases that I looked up when I left the session hall yesterday, but I will just quote a 2010 case because, as you know, in law, the later the decision, the more authoritative it becomes. Ramos v. People, 2010. The elements of falsification of commercial documents are, number one, that there be an alteration or a change or intercalation or insertion on a document, that is, it was made on a genuine document, that the alteration or intercalation has changed the meaning of the document, and that the change made the document speak something false. That's the Supreme Court speaking on what is a falsified document. Now, maybe some of us might think that we should call for a handwriting expert, but that is not the jurisprudence. We don't need a handwriting expert because jurisprudence tells us that mostly courts disregard what a handwriting expert says, and it's up to the judge to determine for himself visually whether what he is seeing before him are, as described by the Penal Code, changes or insertions that tend to give a different meaning to the document. So, the importance of this topic in our impeachment proceedings might overshadow the need to hurry and finish the impeachment trial. Because if we can prove, if there is proof on record that the signature specimen cards were falsified as falsification is defined under the Penal Code, then perhaps the court might lean towards considering the maxim, falsus in unum, falsus in omnibus. It is not relevant to say, anyway, the people responsible will have to be accused in a criminal case, and so you have to find somebody who will file an accusation against them. That is completely irrelevant. The question before the impeachment court is, does this Latin maxim, false in one particular, false in all particulars, apply to the instant specimen cards? Thank you.
Thank you. Majority Floor Leader. What's the pleasure of the counsel for the defense?
Thank you, Your Honor. Your Honor, please, before we start today's proceedings, may I be allowed to make a short manifestation, Your Honor?
Proceed, you have 2 minutes.
I would like to appeal, Your Honor, to this honorable body for a re-examination, Your Honor, of Rule 17, Your Honor, of the impeachment court, Your Honor. The rule reads as follows. If a senator wishes to put a question to a witness, he or she shall do so within 2 minutes. A senator may likewise put a question to a prosecutor or counsel. He or she may also offer a motion or order in writing which shall be submitted to the presiding officer. We are pleading for an examination of this rule, Your Honor, to avoid the usual occurrence of what is known as mistrial, Your Honor. Because while it is true that the proceedings of this court as of the moment may not amount to a mistrial, it is equally discernible that it may be raised in the future in the event that the situation goes worse than this. And the reason for this, Your Honor, is counsel, whether private or defense counsel, is precluded from raising an objection or arguing with a member senator, Your Honor. This is not the same rule that we have before, because in the old rule, Your Honor, there is that opportunity for counsel representing an impeached public officer to object to any question raised by the Senate member, Your Honor. And if the objection is raised, the court is under legal obligation to examine the same and deal with its merits. In other words, it is ruled upon whether by the presiding officer whether it should be allowed or not, Your Honor. Now we say that this may amount to a mistrial, Your Honor, because there is nothing left in favor of an impeachable public officer or an impeached public officer. He cannot object, he cannot make any manifestation, and in all probability, as what we have noticed before, the question of a member of this court centers on practically everything, Your Honor. One question may be raised, followed up by another, leading to a request for the issuance of an order requiring the production of certain documents, which document had not yet been proved to be material to the issue or relevant to the subject matter under discussion. Under such a situation, Your Honor, notwithstanding the fact that a counsel or the defense counsel in this particular instance moved for a denial of the motion, still the order is granted, a subpoena is issued, and notwithstanding the fact that a motion for the dissolution or quashing of the subpoena is made, it may likewise be overruled. Under such a situation, we have no other recourse before this honorable court, Your Honor, and probably the only recourse is to go to the Supreme Court of the Republic of the Philippines. Now, that will be rather not only burdensome, but almost a nullity as a remedy, because it will take time before preparing the necessary pleadings, before the same is scheduled before the appellate court, and before any action can be made on the matter. In other words, we may come into a situation where the Tagalog, aanim pa ang kabayo, aanim pa ang damo kung patay na ang kabayo. If the remedy may be granted later, but the proceedings went on, and there is that violation of the constitutional rights of an accused, we submit, Your Honor, that these are reasons enough to warrant our plea for a re-examination of this particular provision, Your Honor, not to favor the defense, much less the prosecution, Your Honor, but so justice may be done, Your Honor, and to avoid what is known in law as a mistrial, which may ultimately result in the nullification of all the proceedings that were held under the old rule, Your Honor. We believe that this is not only asking justice for the defense, but likewise for the prosecution, because the question of the member senator, Your Honor, may be favoring the defense. Not all the time the prosecution.